Hi, good afternoon, everybody. Thank you so much for being here with me today. My name is Romy Jurado. I'm an attorney here in South Florida. The name of my firm, it's called Jurado and Associates. We are here in Miami, 108 in Biscayne. Today, I'm going to talk to you guys about a topic that is very important to me. It's called estate planning. It's basically planning your legacy, planning your future. For those of you that have pets, that have family, that have kids, you know, it's always really important to think about it, not as if you're thinking about death, but as if you're thinking about your future and your family's future, because hoping you guys will go to heaven, you will still see your family and you don't want them to suffer. So I'm going to start our presentation in a minute. Let me tell you a little bit about our firm. Our firm is dedicated to helping the real estate community. We help a lot of realtors and their clients. We focus on different areas of law. For example, we do litigation all over the state of Florida. We do probate. We all over the state of Florida as well. We do estate planning, as we will discuss today, real estate closings all over the state of Florida, immigration all over the United States because it's federal law. We do employment visas, work visas, and that sort. We also help in anything having to do with intellectual property. We do trademarks, copyrights, and with the help of a patent attorney, we also assist in registering patents. We are fully bilingual. We speak Spanish, English, and we really do cater to the foreigners here. There's a lot of foreigners in South Florida, and a lot of times we're able to help them in different areas of law. They come in for one thing, but they end up staying with us for a bunch of other things. So anyway, thank you so much for joining me here today. I am really, really happy to be here with you all. And I will start sharing my screen so that everybody can have the screen and the presentation. After today's class, I will send everybody an email containing the presentation and then hoping the recording. So I'm probably going to be sending that to you guys tomorrow. Please feel free to ask any questions. You can put your questions in the Q&A or you can put your questions in the chat and I will answer as I go. Thank you so much. All right, perfect. So estate planning. That is our topic for today. Again, my name is Romy Jurado, and I'm an attorney here in South Florida from Jurado and Associates. So why do you need a estate plan? Well, first, you want to determine how your assets will be distributed upon death. This is what you need to do in order to decide that. To protect your minor children, you can designate guardians. Who is going to take care of your children if you're no longer able to doing so? To avoid or lessen the risk of family disputes over assets. That is the worst. People are dealing with the death of you or your family member, and now they're fighting each other because this person wants this other person wants that. So in a estate plan, through your estate planning documents, be it a will or a trust, you can say who gets what, how they get it, and then it's very clear and nobody's fighting over it. Now, of course, they can still fight, but now you have documents and they have to respect your wishes. You also want to tell the court what you want to happen following your death. If you don't tell the court what you want to happen with your assets, then guess what? The court will decide according to Florida law, and I will explain that a little further. And to ensure that individuals you choose can make decisions on your behalf in the case of incapacity or death. There are certain documents that we can prepare in order for the people that you choose to make decisions via your health, your wealth, your assets, whatever you want to happen. And I will explain that as well. So all of these things are important and you can decide and manage all of this through your estate plan. So some of the important estate planning documents that we will prepare for you here at Jurado and Associates are your last will and testament, your revocable living trust, advance directives, basically telling how you want your decisions regarding your health to be taken. Who do you want to make those decisions? A HIPAA release so that your family members or friends can receive information regarding your health. A durable power of attorney. This is a very important document because it allows whoever you design to make financial decisions on your behalf in the case you're incapacitated. So it's very important to have these documents. We saw a lot of this during coronavirus at the beginning when people were just taken to the hospital. They didn't have a durable power of attorney. So now their family could not make financial decisions because they couldn't even communicate with the person. So it's really important to have this document, especially for those that are not married, especially then, or that are single. Who do you want to make those decisions? If you don't empower them, they're not going to be able to do so. We are going to talk about forming a limited liability company that also helps be a estate plan. Payable on death accounts. If you get anything from this presentation, please get this. go to your bank and designate who do you want to receive your money in case you pass away. Why? Because then you don't have to have that money go through the probate system. It could be done automatically upon your death. It would be payable to whoever you decide. It doesn't have to be a family member. Just make sure you go to your bank, you get that done, and that you actually see it that it was done. Because I've had situations where the family member tells me, Romy, my father did this, it was payable upon death to me, but now he passed away. We went to the bank and they told me they have no record of it. So you want to make sure if you go to the bank to designate who will receive your money upon your death, that you receive some type of proof that it was correctly done and that you give it to your family member or whoever you decide to receive this money. We're going to talk about joint ownership with rights of survivorship and how that avoids probate. It could also be a estate planning document because now you're taking ownership of a property and it doesn't have to go through the probate system because the deed says who will get it in case of your death. So we're going to talk about that. And life insurance. Life insurance also doesn't go through probate if you say that the beneficiaries are people. If the beneficiaries are if it's your state, then it would go through probate. But we will discuss about that as well. So what is probate? I keep on saying this word. And yes, I love cats. That is why you see a picture of this beautiful cat. So probate is a court supervised process for identifying and gathering the assets of the deceased person. Also to pay out the deceased person's debts. Yes, so the court gets all the assets, not that they don't get it, they list them and then they use the money to pay that person's debt. And then after whatever's left, it gets distributed to whoever the person decides that they will get this distribution. It's either per the instructions of their will or for Florida law, if there is no will or trust. So that is basically probate. It's a court supervised process that we have to go through when somebody passes away, assuming there are assets that are subject to probate. And I will explain that in a minute. So there are assets, as I mentioned before, that are not subject to probate. So if none of your assets are subject to probate, you don't have to go through probate. So for example, we can have real property, right? Property held jointly as tenants by the entirety or joint tenants with rights of survivorship. Tenants by the entirety is a way to own property in Florida where husband and wife take ownership of the property at the same time. What that means is that husband and wife own an indivisible interest in the property. So you cannot divide that. At the moment that either the husband or the wife pass away, it automatically goes to the other spouse without having to go through probate. So if you own property as tenants by the entirety, it avoids probate because it automatically passes to the other spouse. Now, if both spouses pass away, then it would go to probate because both of them passed away. You could also have, that only works for people that are married, legally married. If you're not married, then you can have ownership as joint tenants with rights of survivorship. So for example, if me and my friends own property together, we are called joint tenants. If we want that property to pass automatically to the other, so if I pass, it goes automatically to my friend, and if my friend passes, it goes automatically to me without having to go through probate, that's called joint tenants with rights of survivorship. And you can title property in that in order to avoid probate. We could also have assets titled in a revocable trust. Trust, it's a document that allows you to make decisions of what happens to your assets, even if you're not here. You can be super explicit in the trust. You could say, I don't want my spouse to receive the whole asset. I just want her to receive the benefit because she has a gambling addiction. And if she receives the whole asset, she will lose the money. I've had situations like that. You can say, I don't want my children to receive the value of the property. They only receive the profits of it until they turn 30 because of whatever reason. You don't even have to name the reason. You can do it like that. You can devise your trust however you want, and you can be as explicit as you want. And it allows you to basically manage your assets even if you're no longer here. You could also, through a trust, say that you want professionals to be involved in managing the assets. So for those of you that are realtors, I have seen trusts where the client says, this property will be given to my child. I'm sorry, this property will be sold, and then the proceeds will be given to my child, and I want X realtor to sell it, whenever that happens. You can do it as well. Or this property would be rented out, and I want X person to manage the rentals and give the profits to the beneficiaries. Again, you can be as specific as possible. You can even name the attorney that you want to manage the assets, the financial advisor that you want involved in this. All of that you can do via your trust. Survivor bank accounts also avoid probate. We discussed that if you go to your bank and you say, I want this payable upon death to somebody, then it survives probate. If you have an account, bank account, joint with another person, it should also avoid probate, but please go talk to your bank because we don't want any surprises. Life insurance, IRAs should avoid probate, assuming that the beneficiaries are named within the document. If you don't name the beneficiaries, or if the beneficiary is your state, then it would go through probate. Real property passing to a survivor's spouse or heirs, as we spoke regarding tenancy by the entirety, that also avoids probate. And retirement accounts, assuming you name a beneficiary, it should also avoid probate. So these are non-probate assets. So let's talk about the last will and testament. What is that? A will is perhaps the most basic and common estate planning tool you've heard of. A will allows you to provide instructions, who inherits what. If you die, right, and you have assets in your name with a will, that's called testate succession. If you die and you have assets in your name without a will, that's going testate succession. You can designate whoever you want to receive your assets in your will, but in order for your will to be probated, it has to be valid. So what do we mean by the will has to be valid? Any person of sound mind and 18 years old or of age or an emancipated minor can make a will. It's so important to be of sound mind. So if you have somebody that has Alzheimer's or that has some type of mental, problem, but if they're able to be lucid during that moment, they can still make a will. So just because they have some mental incapacity, as long as they're able to be lucid, even if it's just for the moment while they sign a will, that will still be valid. A will must be in writing and executed as provided by Florida law. You need to be so careful. I have people that tell me, but my will was done by this agency, by this people. And if it's not valid and not executed according to Florida law, the will is not going to be valid. So the testator, that is the person doing the will, must sign the will at the end of the document, not at the beginning, not on the side. It has to be at the end. The testator's name must be subscribed at the end of the will by some other person in the testator's presence and at the testator's direction. So if the person cannot sign the will, that's okay. We can still have somebody else sign the will at the testator's direction. It must be signed in the presence of two witnesses and in the presence of the testators. So they all must be looking at each other, the witness is the testator, in order for the will to be properly executed under Florida law. So if the testator says, yes, there were witnesses when I signed the will, but they were in another room, that's not going to work. And of course, we're not going to have the testator say that, because by the time we probate the will, the testator passed away. So it's so important that we follow Florida law and that it's properly executed in order for the will to be valid. So testate administration, right? That is if you die with a valid will. Then the role of the probate court is basically to distribute the property according to the testator's wishes and instructions in the will. They will appoint a personal representative as indicated in the will. They can nominate guardians who is going to take care of your children in the will. You can also, in Florida, we can have nominate who's going to take care of your pets. You can do a pet trust, so for the protection of your pet, because what I've seen a lot happen, I'm very passionate about animals, especially cats. The person passes away, the heirs go and take everything from the property, they sell the property, they take all the assets, and they put the poor cats or the dog in the shelter. And then the little animal, dies really sad because they were basically abandoned. They don't understand what happened. And then you're in heaven looking at your kitty or your doggy down, and you're super sad because now your animal's left out in the cold. So that doesn't have to happen in Florida. You can do a pet trust. We do it a lot. So if you have any questions, please let me know. All right, so again, through the will, you can nominate guardians for minor children, you can do your pet trust, and you can disinherit specific individuals. Yes, you can disinherit your children, you can disinherit your spouse in certain situations. As long as it's properly done, you want to be extremely specific, because you don't want the people, when you're not here, to fight and to say, no, they didn't mean to disinherit me, that was a mistake. So you want to be as specific as possible. We have drafted wills to disinherit family, and we try to be as specific as possible so that people don't fight. And if they do, so that we can win. All right, so there's certain things that you can do with a will. There's certain things that you cannot do with a will. You cannot divide the homestead property if you're survived by one or more minor children. So if you have minor children, you cannot give away your homestead property in Florida. If you're survived by a spouse, but no minor children, assuming there is no prenuptial or postnuptial agreement between you and your spouse, then you also cannot divide the property, the homestead property. It will go outright to your spouse. Again, as your estate planning attorneys, we could always advise you what you can or cannot do, and you might need a postnuptial agreement if you want to disinherit your spouse, but we can discuss about all of that with you regarding what you can and cannot do with a will, so that if you have a will, you want it to be one that can be enforced. So what happens if you die without a will? That happens a lot too. If you die without a will, then the laws of intestacy dictate how your assets pass on death. Generally, under these laws, your surviving spouse is entitled to all of your individually held assets if you do not have surviving descendants, or all surviving descendants are descendants of both you and your surviving spouse. A surviving spouse is entitled to 1/2 of the decedent's individually held assets if you have surviving descendants who are not the descendants of your surviving spouse, or you and your spouse have surviving descendants jointly, and your surviving spouse also has descendants who are not your descendants. So, and again, we can discuss all of this with you to decipher who would inherit and what happens. Regarding probate, I want to give you guys news that we do offer free consultations regarding probate. We understand you're going through a difficult time when you lose a family member and a loved one. So we want to sit with you, advise you free of cost of what can we do, what can be done, and then assist you to the probate process within the state of Florida. We're able to do probate cases all over the state of Florida. Even though our office in Miami, we can take care of your case anywhere. So if you have any probate situation, anybody passed away, please feel free to reach out to us so we can offer you a free probate consultation. So what if you don't provide for your spouse in your will? This happens too. So let's say you did your will and then 3 months later you get married, right? So you didn't have time to change your will. You were too busy loving your spouse. And then God forbid you pass away. So what happens? So your surviving spouse will be deemed a preterminous spouse. And I'm going to explain what that is in a minute. So elective share, if the decedent spouse did not provide for the surviving spouse or did not provide enough to the surviving spouse to meet the elective share requirements, the surviving spouse can take an elective share in the decedent estate. The elective share is an amount equal to 30% of the decedent's elective estate. Unlike the intestate share, the elective share computations includes the value of assets other than those held in the decedent's individual name, including assets held in the decedent's revocable trust. So if you had a will in a trust and you didn't provide for your spouse and you didn't meant to disinherit your spouse, then your spouse can elect to get an elective share. So if you have a situation or a friend or family where you see that, you know, the person died, didn't put anything in their spouse, in their will, they're still going to be eligible to receive something. And we can discuss that again during a consultation. If they're deemed a pretermitous spouse, right? So if the decedent spouse dies, leaving a will made before marrying the surviving spouse, that spouse does not provide for the surviving spouse may be entitled to a pretermitted spouse share. The surviving spouse is entitled to a share of the decedent estate as a pretermitted spouse if the will was signed before the marriage, the spouse is not provided for in the will, that spouse did not waive the surviving spouse's rights, the will does not disclose an intention to exclude the spouse, and the pretermitted spouse share is equal to the spouse intestate share. So again, any situation where a spouse died without providing for the other spouse, let's discuss, because the spouse may still be eligible for an elective share or be deemed a pretermitted spouse, and we can discuss about all of that during the consultation. Intestate succession. Okay, so this happens when you die without a will. So who gets your assets if you die without a will? So first we ask, was the decedent married when they died? If yes, did the decedent have children? If no, are either of the decedent's parents alive? If no, did the decedents have siblings? If no to all of that, the decedent's property is divided half between the decedent's mother's and father's family in the following manner. If alive, to grandfather and grandmother equally or to the survivor of them. If there is no grandfather or grandmother, to uncles and aunts and decedents of deceased uncles and aunts of the decedents. If there is either no paternal kindred or maternal kindred, the estate should go to the other kindred who survived. If there's no kindred of either part, the whole of the property shall go to the kindred of the last deceased spouse of the decedent, as if the deceased spouse had survived the decedent and then died intestate, is entitled to the estate. If the decedent was married, yes. And did the decedent have children? If yes, then the decedent's property is divided equally among children. If a child is deceased, their descendants receive their share, right? If the decedent was not married and the decedent have children, then did either spouse have children outside the marriage? So we ask all these questions in order to decipher who gets what. It can get a little tricky, but again, we can discuss this, see your particular situation, and see who will get what. And this all happens when the person dies intestate, meaning no will or trust. If they have a will and a trust, then we don't have to worry about this because your will or your trust will designate who gets what. So intestate succession, again, the intestacy laws provide for an order of preference who will be the personal representative. So the personal representative is that person that administers your assets when the assets are probated. You can decide who that person will be in your will, or if you don't have a will, the laws of intestacy will apply and they will decide who will get your assets. Who will manage your assets while your estate gets probated. So for an intestate state, the order of preference is first the surviving spouse, then the person selected by a majority in interest of the heirs. Then if that's not around, the heirs in nearest degree or the best qualified heir as selected by the court. And then lastly, any capable person appointed by the court. If you don't want this laws to apply, then by all means, do your will, do your trust, and decide who is going to be your personal representative and who will inherit your assets. So why should you consider a trust, right? So a will states your instructions, but it does not avoid probate. A will, you have to go through the probate court. Assets held in a revocable trust do not require probate administration. So if you own property in other state, your family would have to open multiple probates and comply with laws in a particular state. So if, for example, you have a person that died in Peru, I'm in Peru, they're a Peruvian citizen, but they have Florida property, we're gonna have to open up a probate state here in Florida because it was titled in their name. However, if we did a trust in Florida, then we no longer have to open a probate here because the trust will say who gets what. Same thing with people that live in New York or in other states. It doesn't matter where you died and where you were a resident of. If you have real estate in Florida, title in your name, you will have to open up a probate here in the state of Florida. In order to avoid a probate, the only thing that you can do is you can have a trust, or you could also title things in the name of a limited liability company. But then if you own the interest of the limited liability company in your individual capacity, that may also have to go through probate, assuming there is no buy and sell agreement within the LLC. So it's important to properly plan your estate plan. If you don't want to go through probate, you want to make sure that you really don't, by seeing what happens if you die with your LLC, what happens if you die with your property. Also, a trust is a private document. You don't have to publish the trust. You can manage and control the spending and investment. You can decide this financial person will be in charge of administering my trust assets. This real estate agent will be in charge of managing the property and selling it when required, all of that. To protect beneficiaries because they are too young or disabled or incapacitated or irresponsible. You know, maybe you don't want to give them the assets outright. You want them to just receive the benefits, but not receive the assets. You want to set aside funds to support them. You know, you don't want them, again, to receive all the benefits outright. You want the assets to be preserved. And to reduce income taxes from state and transfer taxes. Again, we can discuss that to see how you can save via a trust. If you have any questions, I don't see any questions yet, but if you have any questions, please, by all means, feel free to ask. So what is a HIPAA release? A HIPAA release is an authorization that allows an adult or emancipated minor to authorize healthcare providers to release information, protect the health information to named third parties. This was so important. Don't assume that because they're your child, you have the rights to receive their health information if they're over 18 years of age. We've had situations where the child was sick, and I say child, but they're really like 19, 20, 21, they were in university, and they refused to provide information to their parents because there was no HIPAA release. So don't assume because you have children and they're over 18 that you're gonna receive this health information. You're not, they don't have to release it to you. Same thing for your spouse, same thing for your parents. Have a HIPAA release so that you're properly authorized to receive information, okay? In Florida, an individual may authorize the release of healthcare information to an agent executing either a HIPAA release and authorization form or a Florida designation of healthcare surrogate. So we do that a lot, healthcare surrogate. You authorize a person, doesn't have to be your family member, to receive health information or to be able to make your health decisions for you. You can do all of that via healthcare surrogate. You can authorize one person, you can authorize two people to act together. You can say, if this person cannot do it and this other one will do it, you can do all of that via a healthcare surrogate document. I see some questions here. Can a trust prepared in Florida include property out of state? Yes, yes, it can. You can title property out of the state. You can title it in the name of your trust and then avoid probate in those states. So it's really important to do that. Somebody's asking, I buy a house at my name and after I put in yeast. I'm sorry, I don't think I understand that question. If you want to rewrite it, you buy a house in your name and after I put, I'm not sure in what you put. So if you want to re-ask me that question, please, and I can answer it, sorry. All right, next, living will and healthcare surrogate. Again, this is a document where you make a declaration to authorizing an individual to either make your healthcare decisions or receive information. This is such an important document. I saw this during coronavirus at the beginning a lot. People that were friends, people that were not married, they couldn't make any decisions, they couldn't receive any information. It is so important that you do this, please. The durable power of attorney, again, it's a writing where you authorize an agent to act in case of the principal, meaning you, if you're incapacitated. You know, this document will assist you so that they can handle all of your assets, pay your bills if you're incapacitated. You can revoke this as well by expressing a revocation, saying, I no longer want this to apply. You can give the durable power of attorney to one people, two people, three people, whoever you want to act on your behalf, either individually or together. And this durable power of attorney is only available while you're alive. It's not, once you pass, you need a will. The durable power of attorney is not available anymore. And this is not a regular power of attorney. A regular power of attorney will not work if you're incapacitated. The only one that works if you're incapacitated is a durable power of attorney. Okay, and that's us, and that's our contact information. Today was a quick seminar because I like to make it fast about estate planning, but I do want to answer all of your questions. So let's see what other questions you have. So somebody's asking, if I want to create a trust in a tax haven, BVI, Cayman, that have properties in Florida, would that go through probate court? No, if it's a properly executed trust, then it should avoid probate, okay? The trust can be revocable or irrevocable. And revocable trust is one where you can make changes the whole time until you pass away. Once you pass away, it becomes irrevocable. An irrevocable trust is one that you cannot make changes. Once you do it, it's set on stone. There are no changes to be made. An irrevocable trust takes the assets from you. So you no longer own those assets. If you're thinking about planning for Medicaid, that's something that a lot of people do. The look back period is 5 years. And through an irrevocable trust, those assets no longer belong to you, even if you receive the benefit of them. So they don't count them as part of your Medicaid assets to see if you qualify. That's something that we do for people that are planning to do that. Somebody's asking me to go over the difference between LLC and how this affects wills, probate, and other documents in order to avoid possible problems. Okay, so if you own property titled in an LLC, and your operating agreement, that is the document that governs what the LLC does or doesn't do, doesn't say what happens to your membership interest in case of death, that membership interest is subject to probate because the court has to determine who will get your interest in the LLC now that you've passed. If your operating agreement has something called a buy and sell clause, right? That says the company has a right to buy your interest at the moment that you pass, then the company may buy off that interest, so it no longer goes to probate. At what price? Well, the operating agreement would need to state, it could be market value, it could be a predetermined price. The operating agreement can also determine how you get paid. Is it gonna be via promissory note, so you don't get paid at once? Or maybe the company bought life insurance and they were deemed the beneficiary of the life insurance, and now they're able to use that money to buy the interest from your estate. Or maybe your interest in the LLC goes automatically to your heirs, so then now you no longer, and by automatic, we have to see that you have a trust in place in a will so that it voids probate. All of that can be done in conjunction with your will, your trust, and your operating agreements. The LLCs are regulated by the operating agreements that they have. That is why that is such an important document. When we form companies, we draft operating agreements for our clients and we ask them, what do you want to happen in case of death? Think about it this way. You own a business with a partner and now your partner passes away. The operating agreement didn't say anything about anything. It was just a simple document, or you didn't even have an operating agreement. Now your partner's death, who was the one obtaining a lot of business, so now you no longer get that business. The heirs become the owners of your company because it went through the laws of intestacy. So now you have owners of your company that you don't even know. They don't know the business. They're not going to bring you any money because they don't get clients. And now you're in a pickle. And that happens a lot with small businesses because people don't think about to plan these things. If you're in partnership with anybody, you're doing business with anybody, I don't care if it's your family, your friend, your cousin, your lover, whoever it is, you need to have an operating agreement in place to discuss what happens if that person dies. And you need to have an operating agreement in place that discusses what happens if that person gets divorced. I can tell you, people become really feisty and rowdy when they're going through the divorce, and they will find anything and everything that they want to attack. And if their spouse owns interest in an LLC, now guess what? They're gonna want to become owners of that interest or get something from it. So you wanna make sure that your operating agreement discusses what happens in case of death, what happens in case of divorce, what happens in case of incapacity. God forbid you are in business with your partner becomes incapacitated, so they're no longer able to get business, but they still are entitled to receive whatever their interest is and profits from that. So now you have to work harder to provide, to get more clients, to provide, pay them their portion of the LLC. And what do? There is insurance that you can have that protects in case of incapacity. There is insurance that you can have that protects in case of death. And these are all things that you need to be thinking if you're in business with other people, or if you're in business by yourself. God forbid you become incapacitated. God forbid you pass away. What's going to happen to your kids? So to the people that depend on you, you want to think about insurance. Insurance is great. If you properly get it, you see how much you can afford, and then it can work for your business. All right. Can a trust handle everything, or is a will needed as well? So when we do trust, we also do wills, but we do something called a pour over will, which means your will is going to say everything that I have goes to my trust automatically. That's what your will is going to say. And then your trust, it's going to say who gets what and how it's going to be managed. It's so important once you create a trust that you properly title the assets that you wish to transfer to your trust, that you properly title them in the name of the trust. Because if you don't, then guess what? It's not going to help you. We've had situations where we're still having to do probate because the person did a will, the person did a trust, but then they title property in their own name. They never title it in the name of the trust. So now that property still has to be probated. So don't assume just because you did a will and just because you did a trust, it's enough. You want to make sure that you title properly correctly. We don't want to have any issues, okay? Let me see, anybody else, questions? So somebody's asking me if I recommend buying property under an LLC to begin with and not under a person. So if you're buying property as investment, it's always a good idea to buy it under a company to avoid, to have limited liability in case of lawsuits, to take the best tax, the best tax benefit, especially if you're putting it out to rent, to take out all of the expenses from it after you have to pay taxes for the profits. So it's always good to put it in the name of the LLC. If you're buying property to live, then you have to put it under your own name, or you could title it under your trust in order to receive the homestead protection here in Florida, the homestead tax discount here in Florida, because if you title the property under an LLC, you won't be able to claim homestead on it. So again, if it's for you to live, name it in your name, or you could also do it in a trust, and it needs to have special language so you can claim homestead status. And if it's for rent, or if it's to buy, sell, fix, and stuff like that, to flip, it's always advisable to do it in the name of the LLC to have limited liability protection and to get the tax benefits. I don't usually recommend buying property under corporations, because corporations, you pay tax twice at the corporate level or when you receive a distribution, so you're paying tax twice. And yes, you can qualify for S-Corp status, but sometimes it can be a little complicated because you're required to have a reasonable salary. And sometimes when you're starting out business, you're not able to give yourself a reasonable salary because you don't know how much money you're gonna make. So usually I advise buying property under an LLC. Of course, every case is different. Please, let's discuss and have a consultation. I don't see any other questions, so I'm gonna send everybody my presentation. Again, we're here to answer all of your questions regarding real estate, litigation. I have a fabulous group of attorneys. You see them there. Well, you saw them there in the picture. And we're just, here to serve the real estate community. We love realtors. You guys are amazing. And we want to help you grow your business as much as I can. Somebody's asking me about a land trust. Land trust does not give you liability protection, okay? Only an LLC does. So if you're thinking about owning property in a land trust, that's fine, but maybe we can put the LLC as a beneficiary so that you can get liability protection. And we can structure all of that when it comes to real estate, and we can do the closings all over the state of Florida. So reach out to us or reach out to me and I'll be delighted to help you. Thank you so much, everybody. I'm gonna have another webinar about FERPA this afternoon. So I hope you join me there as well. But if not, I wish you all a fabulous week. Bye-bye.